Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to. And the sentencing statute in this case allows for 2 sentences, life in prison if that's set by the jury, and a term of years. All right, so the sentencing the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I get why you say the effect of her sentence is life without the possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
Yes, Your Honor, it does.
And you will agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason that they would, but if they did, and they were to remove the language that says you're no longer eligible for, the language that says you're not eligible for parole if you're convicted of first-degree murder, that's what relevates this effectively to a life sentence we've held, then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those 2 statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that, or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have?
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole, in Parker we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. Mm-hmm. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence, under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, it just didn't follow the sentencing statute, because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, a life sentence with the possibility of parole, but that's not what the statute provides. In the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means, under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute, because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
Okay, and I might disagree with that, because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past, has reformed the parole procedures and the parole. What if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? Do we have to go back and re-sentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was re-sentenced.
The sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was re-sentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look that capital murder is more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
So
that,
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
no, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Okay. Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language, life imprisonment, under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the sentencer, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, The jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times, point-blank range in the face. So obviously, that the circumstances of a homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller-compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Gregg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where we're trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Mm-hmm. Yes, Your Honor.
That doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Gregg to. And we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Gregg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Gregg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Gregg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the Monotone issue, really Gregg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court. And we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Gregg for both competence to stand trial and Monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding and doing a Monotone evaluation based on the fact that Gregg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Gregg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Gregg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct Monotone evaluations, that Gregg said, no, we object to that, we don't want her evaluated, we're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under Monotone, Gregg did not object, and in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under Monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being Monotone evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
Ms. Hartman, Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. I would. May it please the court. So the majority of Gregg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403 whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that?
Yes.
I'm sorry. Where is that in the record?
Let me see if I have that written exactly down here. I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those 3 books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, and I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under Monotone. He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her Monotone insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, "I messed up, don't call the police," things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under monotony. So irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences. Thank you, Your Honors.